You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 57. Do I need to file a divisional patent application? My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com. Or if it's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com. Or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state, so feel free to contact me regardless of where you live. In the last episode, I gave a very broad overview of the types of continuing patent applications. If you didn't hear that episode, I recommend going back and listening to it. In this episode, I'm going to go over one kind of continuing patent application called a divisional application. This is probably the most straightforward one on when you're trying to decide if you should file one. I briefly talked about divisionals in the episode where I talked about restriction requirements. If you remember, a restriction requirement is when the examiner says that you have claims for two different inventions in your application, and you are required to pick one of your inventions for the examiner to examine, and you are also required to withdraw claims directed to the second invention. Now, let's say the first invention gets allowed. What do you do with that second invention that didn't get examined? That's where a divisional patent application comes in. What you do is you file a brand new application that's essentially identical to your first application. But in the claim section, you can take out all the claims that got allowed in your first application, and you just put in the claims related to the second application that were withdrawn. The examiner is then going to examine these new claims in the divisional application. In this application, you have to claim priority to your original application. In one of the first lines in this new divisional application, you have to write in the very first section of the application, there's a heading called cross-reference to related applications. When I first talked about the parts of the application in an earlier episode, you either didn't put this in or you just said none. But here, you write a sentence that says something like, this application claims priority to, and it's a divisional of U.S. application, and then you give the number of that application, and you filed on, and then you say what date it was filed on. And that's all that's really necessary. You have to say that you're claiming priority to it, you have to say it's a divisional application, and you have to say the application number and say the date that the application was filed. If you do that, the examiner is not allowed to look at any prior art that came after your first application. The examiner is going to examine this divisional application like any other application. You'll get rejections, objections, etc. If it issues as a patent, it will have its own patent number, and you'll generally get 20 years from the date of filing of your first application. And this is important. You don't get 20 years from the date of filing your second application. It's from your first application. So when should you file a divisional application? It's pretty simple. If you are required to withdraw certain claims from your first application that related to a second invention, and you're still interested in getting a patent for that second invention, you should file a divisional application. Now, you may decide that you don't want to file divisional because you're not interested in patent protection anymore for that second invention, and then you would just not file any application and you would have that first application. What's really important is that if you file a divisional application, it has to be done while your first application is still pending. Your first application can't be granted, and then you file a divisional. So if you get notice that your first application is going to grant, you have to write down that date and make sure you have filed a divisional application by that date, or else you're not allowed to file it. You'd have to file a new application by itself, and if you do that, there could be problems with prior art that could be found later, or even your own application being used against you. Now that's it for the basics of what a divisional patent application is and when you should file one. If you want help with your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.